So, is the concern here that by virtue of certain states doing what they did as their own state marketplace under the Affordable Care Act, that they were in fact engaged as a market participant and not in fulfillment of a federal mandate, and as a result are now criminally culpable for what they did? So, is one of the reasons why there has been a failure or refusal or intentional obstruction of an effort to move forward on a criminal prosecution of the Affordable Care Act as itself being a contract to commit to a criminal conspiracy that could then also be evaluated within the rubric of consideration regarding a kingpin operation, because different states allowed themselves to engage in different gaming models in connection with their state marketplaces, and now they need to get insurance on what they've already done, i.e., rather than pursuing, for instance, cases concerning the opiate epidemic from a perspective of understanding it as part of either patterns of racketeering activity or violations of licensing and certification necessary for the effective and legal distribution and acquisition distribution of pharmaceuticals, and or honoring laws concerning intellectual property rights and privacy rights connected to acquisition of people's intangible property for R&D connected to the biomed sector, and or basic contract law around informed consent and demonstration of mental capacity in engaging a contract that, among other things, would allow for somebody else to claim that they were in a position to be either a guardian or a representative when it came to divesting or expropriating people's private property or personal property for use in research and development. All of those other legal matters could potentially be criminal charges. And if you have sovereign immunity, presumably you can try to find a way to maintain a illusion of, or a representation of having done it in a civil accountability structure that would then put people under the rubric of sovereign immunity in order to escape culpability or prosecution for culpability, and or would then be allowed to offset that as part of some other paradigmatic change. But if it is not accepted in that manner, and instead, by virtue of acceding to and allowing for participation in the competitive marketplace aspect, then really what would be needed would be to demonstrate that specific states allowed for the contract that is the Affordable Care Act and the state marketplace mandate to be used as a sort of local or state contractual basis around which to engage in illicit activity, up to and including crimes connected to criminal drug or operations within their own state. So, what you've done is you've pretty much created a sort of micro replication of the concept of a kingpin evaluation of the Affordable Care Act as a contract to commit to a criminal conspiracy. Now, if I recall correctly, there were some states that made a specific challenge around whether or not to allow Medicare or state Medicaid marketplaces or state Medicaid options to be made available under the Affordable Care Act. But in terms of actually identifying the constitutionality of the Affordable Care Act from more than just a perspective of being a market participant and having to deal with consumer choice, I do not recall there being an effective legal challenge that actually addresses the profundity of what the Affordable Care Act is. So, depending upon what happens today, we might just have more leverage in actually pursuing a state by state case for charges of a criminal drug conspiracy that was allowed to be centralized and or officiated or vitiated, as it were, under the alleged auspices of a piece of federal legislation that was itself. So, insofar as the Affordable Care Act is a contract to commit to a criminal drug conspiracy, then what each state did needs to be evaluated as if it were a subcontract to commit to a criminal drug conspiracy.